Today is the last day on your side.
Yes, my lords.
Last day on your side.
We have accordingly arranged.
Yes, sir, that's what.
I don't know how long.
No, we don't know. We had to, from day one, we have said that 4 days this side, 4 days this side. And we have been telling the learned attorney as well as SG that the timelines have to be followed. No accommodation. You redistribute the time amongst yourself if you so desire. Yes, proceed.
Please. Very briefly, I just recap. I was concluding my arguments on the interpretation of.
You are already concluding.
Yes, on Article 200, my lords. On Article 200. Just very briefly, I'll recap that. And then go on to the next point. Well, I had respectfully submitted before your lordships.
So you stopped at 3 options.
Yes, yes. So I said that there are 3 clear options in the main part, which talk about shall declare, and each has a finality or a consequence attached to it. Withhold of assent means the bill falls. Assent means it becomes a legislation, and reservation for the president means it goes for the president for his assent. The proviso is more in the nature of a preliminary option or a consultative process.
You already argued.
Very sensitive to it. The words at the end of it, which are shall not withhold assent, have been sought to be argued to mean that it is an adjunct to withholding assent, which it is not.
They have not yet started the argument.
No, my lords, even in the ultimately, my lord, somewhere or the other, what was argued in the Tamil Nadu matter comes in. And that is why I'm just saying this, that one of the arguments forwarded was that since the last line of the proviso says, shall not withhold assent, it necessarily means that the proviso is an adjunct to withholding shall declare and withhold assent. As I respectfully submitted that neither the textual context indicates it. The judgments clearly say shall fall. And unless can surely, even by the ordinary dictionary meaning as used in those judgments, never be meant to mean that if you withhold assent, it must be sent to the assembly. Unless can never mean that. Unless is a consequence that it shall fall through, unless of course it is sent, where then it's deliberated again. That was as far as 200 is concerned. My next argument, my lords, for your lordships' kind consideration and the historical significance I had shown, your lordship said there's no need to go into it because there are judgments on the point. Returning was a distinct option given earlier from the 1919 Act right through. Return was a distinct option. 3 in the main part and proviso. There it was in the main part in the 1919 Act, then it evolved and became a proviso, but it was always a distinct option given therein, my lords. The second point for your lordship's kind consideration, my lords, is that does discretion exist in Article 200 and 201 or not? My lords, your lordship's repeated judgments on the points have said that this decision will be made irrespective of any advice from the Council of Ministers, and the exercise of this discretion, the governor must discharge his duties to the best of his judgment, is what Shamsher Singh says, and followed then in Navam Rebia and B.K. Pavitra. It was again sought to be argued that discretion is completely bound and there is no independent discretion by the aided advice. That was specifically rejected, and this is what was said. Now, my lords, please have Article 167 of the Constitution for a minute.
One 167.
167.
Yes.
My lord, it says, it shall be the duty of the chief minister of each state, and please have B, to furnish such information relating to the administration of the affairs of the state and proposals for legislation as the governor may call for. The parameteria provision for the president, my lords, is Article 78. The reason I'm citing this, my lords, is that even with regard to Article 167, which in the draft constitution was Article 147, it was sought to be argued that what is the need for information to be given to the governor? For a proposed legislation, why does governor need information at all from the ministry? Why is the chief minister or the prime minister? The words in 78 are prime minister. Why is the prime minister or the chief minister duty bound to give information to the governor? Because after all, he just has to give his assent. And Dr. Ambedkar, my lords, there specifically said that in fact the governor's duty, and as part of his duty, he must get this information because it is his duty to advise, to warn, to suggest alternatives, to suggest reconsideration is part of his duty. And he has to be given that information, because if you do not give this information, what is the governor there for? That's what Dr. Ambedkar said. Because he ultimately is not a representative of a political party, but represents the people of the state. As the president, as the highest constitutional authority in the country, represents the people. And Dr. Ambedkar went on to say that otherwise he would be an absolutely unnecessary functionary, no good at all. And then said he's not a representative of the party, he's the representative of the people.
It is a vital link between the state government and the central government.
Very grateful, very grateful. And my lords, why I'm citing this example is that the reason information on proposed legislations, there are memorandums in existence where information, when a bill goes to the president or the governor, memorandums on information is asked from ministries on center state implications, on repugnancy, on issues of constitutional concerns. And after this information is exchanged, an independent judgment, an application of mind takes place, and that is why the constitution benches say, irrespective of the aid and advice of the Council of Ministers. That's the point I'm seeking to make for your lordship's kind consideration. In fact, my lords, in B.K. Pavitra's case,
According to you, even if second time also the Council of Ministers reiterates the bill, still the governor has a discretion not to give access to it.
no, my lords, if the assembly reiterates a legislation, the constitution is very clear. Then after that, he can either give an assent or send it to the president. He shall not withhold assent. I'm not saying that he can still withhold assent, because that would be in the teeth of what the constitution says. All that I'm saying is that the exercise of discretion by the president or the governor, as far as this issue is concerned, involves an independent exercise of opinion and judgment. As far as shall withhold assent is concerned, as far as shall assent is concerned, as far as shall declare that it is being reserved to be sent to the president. It is his independent exercise is all that I'm saying. I'm not for a minute suggesting, my lords, that if he sends it for reconsideration as the fourth option, as a part of a consultative process, because ultimately, my lords, the governor under 168 is also part of the legislature. And your lordship has said that he is part of the legislative component, is what your lordship said in next. So as part of that legislative procedure and component, as part of it, if he sends it back with suggestions, with considerations, as I respectfully submitted on the last date, there could be cases where he's willing to give assent because he feels some things need to be tweaked. It could be cases he feels before it's sent to the president, certain things need to be addressed. So that is part of that consultative process that he sends it back to. But yes, of course, after that, if the legislature in its wisdom reiterates it in whatever form, his right to withhold goes. But his right to withhold in the main part is an independent exercise of his discretion. And the consequence of it is contained in the constitutional bench judgments to say that it shall fall. That is what I was saying. The second argument,
It's already
Yes, so
elaborately
the
argued by the learned scholars.
yes, so the second argument that I'm making for your lordship's kind consideration is this independent exercise of judgment and discretion. As is borne out by these judgments, this is his judgment which matters. In fact, my lords, in B.K. Pavitra's case, an issue arose that when the governor refers a matter for consideration of the president, should there be grounds on which he can refer it? My lords, this court answered it by saying that the framers of the constitution deliberately and carefully eschewed defining the circumstances. You can't define circumstances under which a governor refers to the president. There are issues and issues of constitutional concerns, complexities which will arise. And you can't put them in a straitjacket formula. That will have to be left to the wisdom of the governor. And that's for him to define and decide. And they said that the very nature of conferment of power cannot be confined to specific categories, were the words used by the Supreme Court. That's the very nature of conferment of power that is granted there. So you can't say this will be in this straitjacket formula, only then we'll do it. That has to be left to his wide discretion, which is vested. Now, my lords, as far as the issue of discretion is concerned, my lords, as my lords have also pointed out, under Article 163, one is by and under the Constitution. Then there is 163(2). And your lordships in any number of judgments have said that it could be explicit or it could be implicit, depending on the facts of a case. For instance, my lords, under Article 174, normally, my lords, as held in Shivraj Chauhan's case and other judgments, a house is summoned or a session is summoned on the aid and advice of the ministers. Yet there can be a situation where the governor is of the view that the council of ministers or the government has lost the confidence of the house. And in that case, he's not going to wait. The council of ministers which has lost the confidence of the house is going to suggest there should be a floor test. That's an independent view in discretion that he exercises under 174. To have a floor test or a summoning the house to prove your majority on the floor of the house. All that I'm saying is there are any number of instances where, my lords, the discretion has been vested in the governor or the president, whether explicitly or implicitly. My next submission, my lords, for your lordship's kind consideration is on the issue of timelines. My lords, in Purushottoman Nambudri, the judgment which the learned solicitor had also cited, it has been clearly held.
Which judgment?
My lords, Purushottoman Nambudri, just get the citation.
Purushottoman.
Yes.
Yes.
My lords, that was 1961 SCC Online Supreme Court 361, Volume 3 of the compilation, the judgment of a constitution bench. The issue was also, my lords, does a bill lapse with the assembly, with the life of an assembly? They said no. Even when life of an assembly comes to an end, for the reason that there is no timeline provided.
That the learned solicitor has already.
Yes, so I said so, my lord. The learned solicitor pointed out there is no timeline, where in fact, my lord, the timeline requires to be provided. The timeline in the constitution is categorically provided therein.
That chart also learned solicitor.
Yes. So, for instance, under 201, there is a time period given.
You may argue what is not argued.
Very well, my lords. So, my lords, as far as timelines are concerned, my lords, our respectful submission for your lordship's kind consideration is that, again, as far as those memorandums, etc., are concerned, where information from ministries is asked for, memorandums are considered, etc., it is impossible to say that within this timeline, the governor or the president must decide. Because there will be all kinds of procedural and substantial complexities. There will be issues, there will be a back and forth.
That is already argued.
Yes. Next point for your
At length.
At length. Next point for your lordship's kind consideration. My lords, your lordships have time and again on the issue of judicial review said there is, and on this I'll devote some time, my lords, that
Scope of judicial review.
scope of judicial review.
by considering the discretion exercised by the governor.
That's right. That's right. Including the issue, my lords, which my lords flagged to me, that suppose there's a constitutional vacuum. Your lords are kind enough to point that's a concern. I'll deal with that. My lords, there is no doubt that in any number of judgments, your lordships have held that the power of judicial review is implicit in a written constitution unless expressly excluded. There's no doubt about it. It is written in for every power vested under every provision. The power of judicial review is there. But your lordships have also consciously, my lords, in AK call downwards in judgments have held that as a facet of judicial review is justiciability. And there is a difference between judicial review and justiciability of a particular action. And your lordships have also held.
That is also argued by the learned.
Malas, I need to argue something.
No, you can argue.
I'm just developing on that.
We are requesting, please don't
Yes,
take
yes.
the argument which are already.
I'll just develop and just leave it. The reason.
Otherwise, Mr. Jetmanani will never get a chance.
Yes, no, Malas,
If all of you are going to again argue what has been argued by the solicitor.
No, my lords, we won't. The reason I'm saying so is, my lords, the reason I'm saying so is that the action of judicial review is always tested on the touchstone of the Constitution. Now, as far as justiciable, manageable standards are concerned, my lords, your lordship says that where there exists none, the action is not susceptible to judicial process. That's all that I'm saying in these cases. Now, why I'm...
Please repeat your argument.
My lords, I am saying that where there are no justiciable standards on a particular action,
Where there are no justiciable standards.
for a certain action,
1 minute.
Oh, justiciable.
manageable, justiciable, judicially manageable standards is what AK call refers to.
Really manageable.
Judicially manageable standards. Where there are no judicially manageable standards to judge an action, it will not be susceptible to judicial process. So within judicial review, although it's inbuilt into the Constitution under every provision, there will be actions which are non-justiciable. Because, as the Supreme Court says, there are no judicially manageable standards for them. So no one is saying that the power of judicial review is not implicit. The power of judicial review is implicit in every provision. But there will be certain powers, there will be certain discretions vested, which do not have justiciability aligned to them. Because they're incapable of being adjudicated upon. And I'll tell you, lordships, I'll give you lordships examples as far as this exercise of power are concerned. Any judicially manageable standard requires an objective, ascertainable criteria. Now, effectively, my lords, in exercise of all these decisions, there is a certain operational and substantial complexity. There are considerations of stakeholders. There are interstate relations. There are consultations with ministries. There are conflicting public interests which are involved. There are constitutional conventions and not just basic fixed rules involved. And that is why I say, my lords, this cannot be compared to the exercise of power under Article 356, and I'll just come to that. This is sui generis in itself as far as the exercise of power by the governor and the president is concerned. Under 356, my lords, for instance, when your lordships in Mumbai and other judgments dealt with, there is a failure of a constitutional machinery. There is either a report from the governor or otherwise, and a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution. That the court felt in the given circumstances was something subject to judicial review, and of course, if arbitrariness or malefides are shown therein. All that I'm saying is this form of judgment and exercise of opinion of the governor and president by its very nature is not justiciable. Now, the question that Your Lordship is supposed to be on the last date.
Discretion under section 356.
Please?
If the discretion exercised by the governor under 356
Yes.
is justiciable,
Yes.
then why not a discretion?
Yes, my lord, that's exactly what I'm answering.
201
That there are contours where it is justiciable, breakdown of machinery, failure, report of a governor, the government cannot carry on any longer. All that I said was there are a lot of substantial and constitutional complexities when a decision is made under 200 and 201. Stakeholders, interstate relations, constitutional concerns, constitutional conventions, and then a judgment in his wisdom is made on these parts. And that is why your Lordship said that even an assent given by the president is non-justiciable. Your Lordships categorically held that neither the legality or the deliberation as far as the assent by the president is concerned is justiciable. In Kaiser Hind and other judgments, your Lordships have categorically held that and in Hext, I think, that the assent given by the president is non-justiciable. And why did your Lordship say that the assent given by the president is non-justiciable? I'm trying to draw sustenance to that argument by saying because there are no legally manageable standards to determine that. That's an issue which is decided in the wisdom by relevant material which is before them. And the argument cannot be, my lords, the argument cannot be that what happens if a governor sits on a bill indefinitely? For the simple reason, my lords, that your Lordships have time and again said that the court will not lightly presume abuse or misuse. And then what your Lordship said that the court,
when the power is exercised by the high functionary.
At the highest constitutional functionary of the country or of the state. And then the words used by your Lordships were that the court would, as it should, in Bomai. The words used were the court would, as it should, tread warily, making allowance for the fact that the President and the Union Council of Ministers are the best judges of the situation, that they alone are in a possession of information and material.
President and Council of the Ministers.
And because that there it was of the advice on dismissal. And that. The issue here is, they said the words used were that the Constitution has trusted their judgment in the matter. Why I am emphasizing this, my lords, is that the starting point can't be that there will be a misuse. If there is a misuse, my lords, the argument is not that the court is powerless. The question is it something, very often, my lords, your Lordships have said in this and many other matters, your Lordships have said on many issues, Parliament shall rethink. Then your Lordships have said that at the cost, in fact, the words used in one of the judgments was, my lords, at the cost of repetition, we observe that it is for the Parliament to take a call on that. There are issues which can only be decided by Parliament or in the political sphere. So if a situation arises of an egregious conduct by the governor or any other constitutional authority, then Parliament has to take care of it. The answer can't be today to lay down a timeline and then say this timeline will be judicially reviewable. The answer can't be that. And my lord, the Chief Justice self had pointed out on the last date, I'm not even going the route of those Telangana and other judgments. Your Lordship said with regard to the Speaker. Your Lordship said tribunal, and not only that, my lord, your Lordship also said
there is no immunity available to the Speaker when he acts as a tribunal.
Not only that, my lord, the other thing which weighed with your Lordships was that the life of an assembly is 5 years, and why should anyone who is otherwise incurred the wrath of defection should continue as a member of the House? And that was one of the considerations.
On the same analogy, when the houses, both the houses of the legislature, on 2 occasions, have given their approval to a particular bill, why should the President sit on the governor committee to sit on it for an indefinite period of time?
I am not for a minute suggesting, my lord, that he should sit on it for an indefinite period of time. I am only arguing.
We may appreciate that we may not fix our timetable, 15 days, 30 days, 45 days. But if somebody sits on bail from 2020 to 2025, should the court be still powerless?
Manas, that is why I started on the presumption that...
we appreciate your submission that for considering a validity of a provision, the abuse of process or the abuse of powers when particularly they are exercised by the highest constitutional functionary, should not be strictly assumed by the court. We appreciate that submission. That is also the submission made by the learned solicitor.
And also, my lords, your lordship's judgment which say that the presumption is raised that the power will not be misused.
Yes, we are aware about
Yes,
that line of judgment.
absolutely. So all that I'm saying is, my lords, if a situation like that arises, I'm not for a minute suggesting that an egregious conduct on the part of the governor, then the question is who takes care of it? My respectful submission is this is an area which is best left to Parliament to decide on. Because your lordships in many judgments have said, that it is time for Parliament to rethink. Your lordships have also said that it is for Parliament to take a call on that.
Telangana judgment itself.
Absolutely. In fact, I know those are your lordships, the lines. However, at the cost of reputation, we observe that it is for the Parliament to take a call on that. So all that I am saying is, my lords, that ultimately when your lordships interpret a provision also, including the 5 judges and Manoj Narula, your lordship said that ultimately some interpretation has to be based on some resting pillar or strength on the basis of some words in the Constitution. Your lordships have repeatedly said that when an interpretation is given, there has to be a resting pillar. There has to be some strength to it, to words in the Constitution. You can't rewrite the Constitution. Those are your lordship's words, is all that I'm saying. So an interpretation which completely rewrites or introducing timelines which are not conceived, which are not there, because it is presumed that if it is misused, this should be the timeline. That's why I said, my lords, in all humility, the starting point of this debate can't be that there could be a vacuum, we apprehend someone could misuse. It may have happened in a particular case. I'm not on any particular case, I'm on the principle. It can't be that the presumption will be that there will be a misuse, and thus we must, as a constitutional court, set it right by setting down timelines. That's all that I'm saying. Because after all, your lordships have said that it will not be lightly presumed that the power will be abused. And we'll tread very warily and carefully as far as these issues are concerned. That's all that I'm seeking to say.
That's what the solicitor also said.
Yes. Now, my lords, the next point for your lordships' kind consideration is,
So all the same arguments why 5 lawyers would not make it strong.
no, my lords, I'm just completing. Well, I'm just completing in 10. Give me 10 minutes and I'll complete it.
We are not talking. We are only saying that it doesn't mean that the same
No,
argument need to be repeated by every.
No, my lords, we are just in 10 minutes and we are complete. Yeah.
I appreciate it if somebody comes up with a new point.
Yes. My lords, as far as deemed assent is concerned, in any matter as was given therein, my lords, under Article 142, my respectful submission is only one, my lords, that this is completely impermissible judicial reallocation of constitutional functions from a high plenary constitutional authority, that is the president or the governor, to the Supreme Court. It's completely impermissible that such judicial reallocation under the constitutional functions can take place. It is impermissible. As far, my lords, as the question of seeking the opinion of the Supreme Court is concerned before any assent being given, my respectful submission is, my lords, in repeated judgments, your lordships have held that judgment opinion of the president on assent is non-justiciable. He weighs well within his rights to take a decision, and it's not an idle formality when he takes this decision. It's in a discretion vested in him and not as an idle formality that he takes this decision. Whether it's under 200, 201 or Article 254 or any other article. And surely the opinion of the Supreme Court, when he wants it, he seeks that opinion. And then it's for your lordships to answer or not answer it. I'm very grateful, my lords. I won't take any more of your lordships' time.
Thank you. Thank you.
I'm very, very grateful for your lordships' kind consideration.
Lordship from Maharashtra, Mr. Harish Sarve is appearing online. So Lordship may, if
That you have to decide. Yes.
yes, sir.
We have another sequence. We have a sequence who will.
As per the sequence, Mr. Survey is to follow. Unmute kar do.
Mate, please, Manoj.
Yes, Mr. Survey.
But I've written out a skeletal note so that we can go quickly. I believe starts at page 630.
The submissions, is it?
Yes, but this is more, Malad, it's not a detailed written submission. These are more like headline points and some arguments. And I will quickly, only for giving the background of what the points which I would endeavor to underscore, Malad. I may have to just state certain points which your lordship may have heard, so your lordship can just give me that accommodation. I will not argue those points. In the first 5 paragraphs, first 4 paragraphs is what I call the background to the interpretation. Lord, Article 200 is a part of our legislative procedure. And that's noted. My Lord, before your lordships read this, may I tell my Lord what is the nuance which I propose to place before your lordships for your consideration? In my respectful submission, my Lord, we have to be careful we don't place the cart before the horse. We are a constitutional construct which resembles a federalism, which is like a federalism. But the word federalism, like all political constructs, may be of various kinds. Your lordships have heard this over and over again. The important point is, Manad, how do we define our constitutional federalism? Do we look at our constitution to see how a federation has been created? Or do we interpret the provisions relating to the relationship between the Union of the States with a priori notion that these have to be understood to conform to some theoretical concept of federalism? And I make bold to say, the framers of our constitution have created a system in which the union can refuse a bill passed by an assembly from becoming law. So, my lord, this what is uncharitably characterized as a veto, and I'll say why I call it uncharitably characterized. That exists anywhere in the Constitution, unless we rewrite Article 201.
But according to you, the union can reject a bill passed by both by the houses of the state legislature.
Yes, ma'am. Should it is a matter of high discretion. We always say in rare circumstances.
We are not going into question of should it or should it not.
Exactly.
But according to you, the union has the power to do so.
Yes, madam. And that is plain from the language of the proviso to 201. So this entire exercise of trying to avoid a veto-like power overlooks that the language of 201 does not admit of any such limitation. Now, if that is the starting point of the debate, and we give up the notion that finding a veto is antithetical or erodes a federalism as envisaged by the Constitution, then we come to very different conclusions. Two articles which have not been addressed are the width of 361 and judicial review. And ultimately, Malad, we all come to they will all lead to the same conclusion. Whether you look at it from the justiciability point of view or you look at it from the functional and the operational point of view of how these articles operate, the conclusion will be the same. And that's what I propose to Malad, put across your lordship's kind of consideration. If vetoes are not an anathema to the constitutional scheme, then let us start without any preconceived notions, seeing what the language of Article 200 leads to.
So according to you, the governor has a veto power under Article 200 to withhold.
Using words like veto perhaps are an uncharitable characterization. The governor has the power to withhold assent. When he will withhold,
you only argue that if vetoes are not anathema to the Constitution.
Malad, I said what is uncharitably characterized as a veto. Malad, I said what is uncharitably characterized as a veto. But it's a convenient shorthand expression. Malad, I call it that's why in my note also I've said it's uncharitably characterized as a veto. Veto has certain pejorative consequences which you don't use for high functionaries. A veto is something you use for personal interest. Nobody here acts in personal interest. Now, to get to where I have, there are 2 or 3 basic points which we need to keep in mind. And this is our federalism. What defines our federalism? Let's be clear. The Constitution, if your lordship has para 1.2, I made this point. We have a marked difference in the scheme in relation to the legislative provisions relating to the union and the role of the president vis-a-vis the union government, as against the legislative provisions relating to the states. So we start from there.
Just for sake of clarification.
Yes.
Your argument was that the union has a right to reject a bill passed by the legislature.
Yes.
So whether that power can also be exercised by the union in respect of list 2?
Yes. I'll make it good. I'll make it good.
Even if there is no repugnancy with the central law?
Absolutely, Manoj. Under Article 201, there is no such limitation. Manoj, we have always started this with certain preconceived notions. There is a separate 254.2 is a different matter.
What happens to the Constitution reserving subjects in list 1 only for the union, subjects in list 2 only for the state legislature, and in the list 3 for concurrently?
But that is 254.2, Malad, not 201 proviso.
So
there are separate powers.
While reading 200, we have to ignore 254.
No, but they are independent powers operating in independent circumstances. Some of them have conditions precedent, some of them do not. If we start not stitching up these provisions, we are eroding what the framers of
the principle which know is of harmonious construction.
My lord, there is no disharmony. There is absolutely no disharmony. If we start with a premise that any such stymieing of a bill made by the state is antithetical to the constitution, if we start with that premise, then the disharmony starts. If we read the constitution to understand what was the structure the founding fathers had in mind, then the disharmony disappears. So that's why I start by saying we don't start with any preconceived notion. Let's try and find out what the constitution says. And that's why, my lord, I don't propose to cite any judgment. I invite your lordships to read the article.
Yes.
The first is, my lord, let me cut to the chase. If your lordship pick up 201, and my lord, your lordships have been told this repeatedly, and long reasons have been given. I need to only state it. Each word of these provisions was carefully calibrated. Look at 201, where a bill is reserved by a governor for the consideration of the president. The president shall declare that he assents to the bill or that he withholds assent thereof. And provided where the bill is not a money bill, the president may direct the governor to return the bill to the house, or as the case may be, houses of the legislature of the state, and with such message as may be mentioned. And when the bill is returned, the house or houses shall reconsider within a period of 6 months. And again, if it is passed by the house with or without amendment, please mark the words, it shall be presented again to the president for his consideration. Now, my lord, and your lordship has seen the language of the first proviso to 200. I don't need to go to it right now. I will at some point deal with the language. The words shall not withhold assent therefrom are conspicuous by their absence and cannot be read in. We would be rewriting this proviso. This defines Indian federalism. And my lord, there is nothing shocking about this. High constitutional functionaries in a democracy are in the ultimate analysis. But a democracy functions by the good sense of the people.
Dr. Ambedkar in his speech of 3rd of November 1949
Yes,
elaborately expresses about how our federalism works and how it is
Yes.
distinct from the American system.
Correct, madam. And that is very important. If your lordship, the speech has been shown. The essence of that speech was
What he says that except the situations of emergency, the states would work within the fields assigned to them, and the union would work within the spheres allotted to them. And only when there is an internal or external emergency, the power shall stand vested with all the powers shall stand vested with the central government, so that the country is united and strong at the times of peace as well as war. That is the words he uses.
My lord, that is in a completely, may I, my lord, explain? Unfortunately, in some of the cases also, the understanding of 200 and 201 has become competence-centric.
Has become?
Legislative competence-centric. Where Dr. Ambedkar also said, it's only in emergency that least 2 powers become available to Parliament. Otherwise, the states have their own sphere and must function on their own. Well, let's start by propositions which cannot be doubted. The state legislatures are what the Constitution calls them legislatures who have the right to make laws. Having conferred this right to make laws, in our federation, we have two parallel models, the union legislature and the state legislature. And my lord, where the Constitution treats the two differently, we cannot ever say that, or remove that difference by reading down or reading up any provisions relating to either of the two organs. Your lordship has seen the structure, Article 74. Your lordship has Article 74, for example, and see the difference in language and the difference of how the framers of the Constitution made it. 74, and there are two dimensions to 74, my lord, and since I'm showing the provision, let me make that point also. There shall be a council of ministers with a prime minister at the head to aid and advise the president, who shall, please, your lordship knows these words, who shall in the exercise of his functions act in accordance with law. With such advice. And here it says, provided the president may require the council to reconsider such advice, either generally or otherwise, the president shall act in accordance with the advice tendered after such reconsideration. Mark this one with the contrast to the proviso to 201. Then, my lord, we have the legislative procedure in part 5, which begins from Article 107, and this culminates in 111. And I don't need to labor the point that the assent is the last step in the legislative procedure. And 111 says, where a bill has been presented by the Houses of Parliament, it shall be presented to the President, and the President shall declare that he assents or that he withholds assent therefrom. There is no, my lord, any further question of referring the bill to anybody or seeking your lordship's opinion or anything of the sort. Nothing. Provided that the President may, as soon as possible after the presentation of the bill for assent, return the bill if it is not a money bill with a message requesting that they will reconsider the bill or any specified provision, and in particular any desirability of introducing any such amendments as he may recommend. And when a bill is so returned, the Houses shall reconsider the bill accordingly. And if the bill is passed by the Houses with or without amendment and presented to the President for assent, the President shall not withhold assent therefrom. Now, my lord, this article would have had very different connotations if 74 had not been on the statute book. Because all these functions are to be exercised on the aid and advice of the cabinet. But the cabinet cannot alter the bill. If the president in a dialogue with the union cabinet feels that the bill needs to be corrected, he can request, and the executive government, the union cabinet, takes it back to the parliament. The parliament may or may not reenact it, but what comes out of parliament then is the last word. So this is perfectly consistent. The difference here is the president, even while doing so, is acting on the aid and advice of the union cabinet, because 74 is untrammeled. And we do not have any discretionary functions of the president, but that's settled. So, my lord, this distinction, The Constitution has marked in para 1.2, the point therefore which I want to make, is marked difference in the scheme in relation to legislative provisions relating to the union and the role of the president vis-a-vis the union government. As against the legislative provision, this distinction is a characteristic of federalism in India. So this is how our federalism is defined in our constitution. The approach which is based on testing and interpretation of the plain language on the premise that one or the other would be consistent with the principles amounts to defining Indian federalism in abstract terms and then testing the interpretation of provisions on whether the interpretation furthers or distracts from the abstract notion of federalism. This approach overlooks that the founding fathers carefully crafted the provisions and defined the roles of the two legislative bodies in the provisions of the language, which language does not admit of any ambiguity. Reading down any such language on the premise that the consequence would be incompatible with federalism overlooks that the plain language has to be read to define federalism as understood in the Constitution. So, but when we say this is not consistent with federalism, where the language is compelling, you don't stand outside the Constitution to define federalism and then say this construction creates disharmony. By itself, there is no disharmony between two provisions. No disharmony. And one of the points which I will address as I go along is the 254(2) versus 200. It is indisputable that the states have their own identity, but not sovereignty. And where the language of the provision of the Constitution is broad and undefined, an interpretation consistent with broad ideas of federalism may be applied. But to read down the express language of a provision on the ground that it is incompatible with federalism suffers from the fallacy of circumlocution. Because one of these provisions define federalism. What is our federalism is what these provisions provide. The second principle, Malad.
Salve,
Yes.
the issue is not so much about what we can, whether we can use the expression veto or withholding, occurring by virtue of Article 201 proviso by the end of it. By the interplay of 200 and 201, eventually when a president, by virtue of Article 201 says the bill shall be presented again to the president and the buck stops there. We are not so much on that issue. We are much more on Article 201 substantive portion read with the proviso which the union says can't be done and the substantive provision stands on its own. Thereby, the power of withholding stands on its own and the governor can withhold a bill.
Malad, the problem found... I'm so sorry.
So therefore, when you independently exercise the power of withholding, then this gives rise to a fourth option or the adjunct to the second option, that in the event the bill is sent back with a message by the governor, then the assembly will consider and then send it back. That aspect has a little problematic because at the threshold the governor, not the president, at the threshold the governor withholds the bill. Even textually there is a problem because if that's the power, even a money bill he can withhold. The question of proviso won't apply there. There's a big problem in that interpretation. Assuming for a minute, it is permissible to read the substantive provision along with the proviso, and inevitably the governor sends it back in the event he thinks that it needs to be withheld, then it comes back to him. At the second stage, perhaps the governor will be able to send it to the president, which of course Tamil Nadu says it can't be done. And when it goes back to the president, it is only then that under 201 proviso, the process will come to an end. Till that point of time, the legislative process commences with the assembly, goes to the governor, comes back from the governor to the assembly, and then again goes back to the governor. At that time, he will make an option of either accepting by virtue of the first proviso or sending back to the president. Only then it stops. If you don't construct it in that manner, what will happen is, even at the threshold, a bill can be withheld, or as you say, the process of veto will occur. That's the doubt. How do you construct
Yes,
this?
May I answer that straight away? May I answer that straight away? I have a full dress reply, but to my immediate response is as follows. The difficulty which your lordship is pleased to put to me, which has been felt, arises because of the perceived consequences of reading in such a power, not because of the language of 300, 200. 200 language is plain. But the argument is that means that he can.
To us, how do you understand the proviso which says that except in case of a money bill? So then that's not occurring in the substantive provision.
Correct.
If your construction is accepted, then a money bill can be withheld straight away. Then the proviso
Yes.
won't apply.
Yes.
Then he can stop a money bill straight away. At the
Yes, my lord, he
threshold.
can. Yes, he can.
Then read it with the proviso now.
Yes, my lord, that's what I'm saying. If we, for a minute, my lord, please look at it a completely different way. Let's put the proviso to one side first.
Please explain, sir.
Yes. My lord, look at it in the reverse.
Yes, Mr. Sir.
Yes. My lord, please look at it in the reverse. Without any preconceived notions, I pick up the book and I start reading 200. Where a bill has been passed by the legislative assembly of a state or of the state having a council having been passed, it shall be presented to the governor, and the governor shall declare either he holds assent or that he withholds assent therefrom, or that he reserves the bill for consideration of the president. But this is untrammeled by any such limitation. If the framers of the constitution knew that there is a separate class of legislation called the money bill and made detailed provisions for money bills, all that they had to do is shall either assent to the bill, or in case of bills other than a money bill, says he withholds assent. Simple. That is how what I would have expected to find if 200 was not to apply to money bills. What we are doing is we are not picking up words from outside the provision and adding it to the provision because we feel that there should be some limitation. Now look at the proviso. Provided that the governor may, as soon as possible after the presentation to him of a bill for assent, return the bill if it is not a money bill, which means one of his three options is limited. What are the three options the governor has? Well, I've tried to formulate it in para 1.5 and 1.6 of my note. The governor is under a duty to make a declaration when a bill reaches him. But I'm not getting into the timelines. I think enough has been said. The governor has a duty to make a declaration. The plain language says the governor shall declare. So he has to make a declaration. So the three declarations are, my lord, I have tried to paraphrase them in 1.6.1, declaring that he assents to the bill, declaring that he withholds assent therefrom, declaring that he reserves the bill for consideration of the president. He then has a fourth option. He returns the bill together with a message to the assembly. Now the fourth option is being used to emasculate the first option. Now that is, in my humble submission, a complete, unless you start with the premise that, oh, it could not have been ever intended that the governor will have this power. So let's search for some kind of limitation, some implied limitation. If we read the plain language, it's very clear. And these are not high constitutional functionaries acting in enacting legislation. There are so many pointers in the language of 200, which if carefully read will show this entire exercise, my lord, would not really. The second important thing, madam, and this is telltale. This is almost compelling logic which shows that the proviso cannot be read into the main part. Please turn to the language of the proviso. The proviso, if, my lord, the interpretation of reading the proviso into the main part is correct, the simple expedient would have been provided that the governor shall, as soon as possible, return the bill for which assent is withheld. It would have been as simple as that. There would have been a question of may. Where is the question of saying provided the governor may as soon as possible? And in a same proviso which uses at the end the word shall. So we can't even say, my lord, that it is high constitutional functionaries. So the lawmaker used the word may, and may really means shall. Because for the same constitutional functionary in the same proviso, it uses two expressions, may and shall.
That may is used in the context of two other options that the governor has when he is referring.
Correct.
He will send it back for reconsideration of the bill of any provisions, and in particular will consider the desirability of introducing any such amendments as he may recommend.
I'm sorry, my lord. The moment we say this is an option, we have displaced the premise that this has to be read into the main part. This is then a separate option. And it is may. It is not that if he withholds assent, he shall send. We have to rewrite these provisions, Marat, to come to the conclusion that this power to withhold is limited only to cases of sending back.
But how do you reconcile this issue about the bill? That's my last question to you. How do you reconcile? How do you reconcile that a money bill can be rejected at the outset by the governor, by the substantive provision, and then the later portion says, then again he has the option. He says that return the bill if it is not a money bill.
So, my lord, as far as
he can only withdraw at the, he can only withhold at the outset. Money
My
bill
lord,
can
please.
withhold only at
Yes.
outset. I'm having
Yes,
a
my lord.
problem about
That's,
reconciling the proviso with money bills.
yes, my lord, it's not a question of reconciling. It is asking the question, with great respect, asking the question, why did they make it for other than money bills? The answer is very simple. Grant of assent.
Mr. Salve, only if you can give me a minute.
Yes.
Absolutely.
207 is the answer, my lords, to my Lord Justice Nasima's question. Special provisions as to financial bills. My lord, 199 is, my lord, financial bills, which is
Money bill, money bill.
Yes.
207 we have.
Yes, my lord. A bill or amendment making provision for any of the matters specified in subclause A to F of clause 1 of article 199 shall not be introduced or moved except on the recommendation of the governor. And so he cannot, there is no question of withholding.
Therefore, then your argument that he can withhold under the substantive provision goes. In the substantive provision, your whole argument is that it is open-ended and it can be withheld by the governor.
No.
There is no occasion for withholding a money bill because the introduction itself is with the recommendation of the governor.
So therefore, in a money bill, there is no withholding.
Yes, my lord. Yes. Your lordships are right.
The presentation is with recommendation.
Yes, your lordships are.
207 requires the consent of the governor.
What he's saying.
My apologies.
May I, my lord, point out, there may be a third situation.
Please consideration.
I was going to deal with 207, my lord, but there may be a third situation. I just want to test it. A money bill is introduced with the recommendation of the governor. The bill may undergo changes on the floor of the House. It doesn't say that the money bill is introduced has to be passed. If what is approved finally doesn't accord with what was recommended by the governor may withhold assent. The point is, my lord, important that the framers of the Constitution created a separate safeguard. In 207, and perhaps did not consider it necessary in the light of that to extend the fourth option to money bills. I wonder if my point is clarified. I am not saying that the assent to a money bill cannot be withheld on its plain language. But it will be extremely odd and therefore all argument of abuse, which should never be brought in, to say that having recommended a bill, the governor will then withhold the bill. But where the power should be exercised, how the power should be exercised, and the existence of power are two very different questions. What your lordship's question is, and I assume that's what I'm addressing, the existence of power, not how it will be exercised.
No, we are not on the question of abuse at all. We are on constitutional
Exactly.
interpretation.
Exactly, existence of power. That's right. So, my lord, existence of power to withhold.
While deciding this matter, we will not be looking at the Tamil Nadu fact.
No, but my lord, I see that. I see the wisdom of that, my lord, because the old story of hard facts, bad law, my lord, should not visit any such matter of such a moment. Article 200, my lord, in the fourth option of sending back removes money bill because that has already been done. If despite that, if the money bill as recommended is accepted, I'm answering my lord Justice Narasimha's question. If the money bill as extended is what is passed as recommended by the governor, in theory, he may have power to withhold, but the question of exercising that power would not really arise. But if the money bill as recommended by the governor is not accepted, because nothing prevents my lord on the House to make changes to the money bill. A bill which finally comes for assent may not accord with what was recommended. The governor may withhold consent. Now, if the fourth proviso did not accommodate money bills being sent back, it was because if your recommendation has already been there, if that recommendation has been disregarded, there is no question of sending it back. Then you decide you either grant assent or don't grant assent. The proviso was meant in recognition of a very important principle in a democracy, the principle of consensus. That if the governor sends the message and it goes to the assembly, he is then trusting it to the wisdom of the assembly. The wisdom will act with responsibility, will consider the governor's message, and then will pass it. And in which case, their word, as far as they are concerned, the governor then doesn't have the power to withhold assent. Now, the argument against this construction, that do not construe this so widely as recognizing this power, is because you are creating a veto. Malad, this word veto doesn't fit in constitutional debate. What we are saying is you are creating a power, or you are interpreting the provision to show that the power of this high constitutional functionary may extend to stymieing a bill and prevent it from becoming law. Well, I submit that is quite consistent with the scheme of the Constitution when you read 201. So if the governor sends it back and it comes back to the governor, then his 2 out of 4 options are ruled out. He then can either grant assent or he reserves the bill for president's consideration. Withholding assent is ruled out and he has already gone through the assembly. He can't send it back a second time. In other words, the controversy then moves between the union and the state. The judgments have been shown, and that's why I'm not citing any of those cases, that the governor ultimately is the points person, is the nodal agency for harmony between the union and the states. So he is the first stop. And Malad, it will be, in real constitutional sense, it will be hard to believe that a governor will really act on his own, where there is a strong push from the assembly to pass a law. He may well, to start with, refer it to the president. Or he may try working with the assembly, and if it doesn't work, he may refer it to the president. But the basic notion that once a law is made by the assembly, then an assent must follow is wrong. If it is not a feature of Indian constitutional federalism that an assent must follow after 1 or 2 rounds or 3 rounds of confabulations, and the assembly must have the same power to have the last word as parliament does. If that is not the scheme of the Indian constitution, then Manoj, we have to go back to the drawing board and define what is our federalism. And it is a limited federalism, in the hope that all framers, that all these high dignitaries who have been conferred with this power will act with wisdom, will act to protect the constitution, and will act to further the values of democracy, because these are the assumptions we have to make. This is how it was done, with a final check or safeguard saying, in rare cases, the moment a law made under the heat of the moment in a state may not be allowed to become law. The political process will resolve the political crisis which may follow. But that's not then in the realm of constitutional law. This, my lord, is the absolute plain meaning of the compelling language, unless we start rewriting express provisions such as 200, 201, 254.2, etc., etc. So, my lord, I close this point saying,
The Salve,
yes,
111.
yes,
If a president withholds without application of the proviso, here also there is an expression may in the proviso.
my lord, 74.2 will come into play. He can be advised to present. The president has no discretion. He has to act on the aid and advice of power. So the manner in which this power will be exercised becomes qualitatively different.
How does it? 74.2, how does it?
Yes, ma'am. Please see 74.2.
The question whether any, and if so, what advice was tendered by the minister?
No, I'm sorry, 74.1. I misspoke, ma'am. 74.1.
One proviso, you mean?
No, the main one is that the head to aid a president in exercise of his functions, and this is untrammeled, all his functions, act in accordance with such advice. So if he is advised, if in discussion he can have, but in all these, there is an element of political processes recognized. So the president may call the union government and say, I have these doubts. Do you mind taking it to the parliament? They may say, yes, we take it to the parliament. Or if he advises no, that please give assent, he has to give assent. Because 74.1 is the marked difference. And your lordship has been shown all the cases. The difference between the governor and the president.
That's there, that's there.
So, this is why I submit. Now, my lord, apply 74.1 to 201 proviso. And that is the scheme of Indian federalism. When it is presented to the president for his consideration, it means, and the president will obviously act on the aid and advice of the union government.
Possibly didn't know your lordships are conferring. Mr. Salve didn't know that your lordships are conferring.
I'm so sorry. I'm so sorry.
Withholding assent in the increased budget or what? So according to those, the president is bound by the aid and advice of the Council of Ministers in the Union. The same is not insofar as states is concerned, and the governor has his own discretion.
That's clearly the position.
Yes.
That's a sharp difference between the two. And in the same constitution, my lord, when we have two structures, it was for the founding fathers to have decided. They could have created a similar structure for these states, but they did not.
Yes.
Now, my lord, textually, I have therefore concluding my submissions in para 1.7. The proviso uses two expressions, may and shall. The founding fathers would have and could have provided that the governor, upon withholding assent, shall refer the bill to the assembly if the intent was to limit the power of withholding only for the purposes of sending the bill with a message. The second proviso, now this is another interpretational aid. The second proviso is mandatory in nature, leaves no discretion to the government. So when they wanted to make it shall, they have made it shall. So these are very carefully crafted provisions. The general principle that in certain cases may must mean shall, because when you are referring to high constitutional functionaries, you would use the word may even when you are casting a duty, cannot apply to these provisions because when they want to, they use the word shall. And therefore, my lord, on textual interpretation, the scheme of 200 leaves no manner of doubt that the founding fathers did not intend to make the referral of a bill to the House with a message a necessary consequence of withholding assent. The obvious reason for not doing so was whether governor withholds assent in circumstances where there is a sharp political division. And in the opinion, the bill should not be allowed to become law. There may be cases like this. Needless to add, this is a far-reaching power. And if it is likened to a veto, it only means that the founding fathers wanted to reserve a veto. The fact that such a veto does not detract from the federal character of that there is such a veto does not detract from the federal character as defined in the Constitution. This is our federal character. We must not first see these provisions and say whether India has a federal constitution or not, and to what extent. It's not the other way around that we start with that India has a federal constitution. Now let's start chipping and